Constitutional Law 1, Lecture 8, Article 20, Protection to Accused Persons. Dear student friends, you are aware that I am Dr. Rega Surya Rao, Principal, Retired, Priyadarshini Jnana Prabodhi Law College, Fulton, Satara District, Maharashtra, India. After my retirement in 2018, I started delivering lectures online for the last 2 years. So far, I have delivered 117 lectures on 16 subjects. This is my 118th lecture and 8th lecture on Constitutional Law. From this subject, Constitutional Law 1, I delivered previously 7 lectures. In these 7 lectures, I explained in detail about Constitution, meaning, definition, scope, classification, nature of Indian Constitution, federal or unitary or quasi-federal, in particular reference to federal features, preamble, whether preamble is a part of the Indian Constitution or not, with reference to amending power of the Parliament, and fundamental rights I delivered in 2 lectures. Fundamental rights part 3, article 12 to 25. All these articles in brief in 2 lectures I delivered. Thereafter I delivered one lecture, article 21, the most important topic. Thereafter in the last class I explained in detail about article 21 in detail and elaborately. So far I have delivered 7 lectures on Constitutional Law 1, and this is my 8th lecture. In this lecture, I wish to take up one of the most important articles among fundamental rights, Article 20 of the Indian Constitution. As I told you in my previous class, Part 3 of the Indian Constitution deals with fundamental rights. Under Part 3, there are under Part 3 from Article 12 to 35, various provisions are provided, various fundamental rights are provided. From among these fundamental rights, some fundamental rights are designed to citizens, non-citizens and legal persons. Some fundamental rights are designed to specific persons. Some fundamental rights are designed to citizens and non-citizens, that is foreigners. So articles like Article 14, 19, 21, those articles are designed to all persons, so citizens, non-citizens, etc. Whereas some articles like Article 20, Article 9, 29, 30, they are specifically designed to some particular category of people. For example, Article 29 and Article 29 and 30 provide some constitutional rights to special rights to minorities. Under Article 29, the minority communities can conserve the language of their own. Under Article 30, they can establish and administer the educational institutions of their own. Similarly, some special rights, constitutional rights are provided for prisoners, bonded labor and others. So like this, Article 20 is designed for some specific category of persons. They are accused persons. So this article refers to criminal law, accused persons only. Who is accused? All these aspects I will explain you in detail. So this Article 20 contains 3 clauses. There are 3 clauses under Article 20. Article 20 Clause 1, Article 20 Clause 2, Article 20 Clause 3. So these 3 clauses deal with 3 most important concepts pertaining to accused persons. Accused persons. So an accused person is one. An accused person is one who is arrested and is under trial, and before the judgment is pronounced, until and unless the judgment is pronounced, we cannot say that whether he is a real culprit or not. If the offense is if guilt is proved, he will be convicted, then he is called convict. If offense is not proved, if the if allegation is not proved, he will be acquitted. Then so that is why after arrest and before judgment as to guilt, acquittal or conviction, his position is he is called accused person. He is called accused person. Suppose a person is arrested on allegation of some murder, rape or something. Whether he actually committed murder or not, one will not be able to say certainly. So for that purpose, he will be arrested. He will be put in police custody. Then investigation will take place. Enquiry and trial from court. Investigation from police level. Enquiry and trial from court level will be conducted. And then only between after arrest and before judgment, that person is called accused person. So Article 20 provides three categories of fundamental rights, three kinds of constitutional guarantees, fundamental rights through Article 20 of the Indian Constitution. So Article 20 of the Indian Constitution contains three clauses. Article 20 clause 1 deals with ex post facto laws. Article 20 clause 2 deals with double jeopardy. Then Article 20 clause 3 deals with self-incrimination. Dear student friends, you are the constitutional one is prescribed for study basically in most of the Indian universities, that is first semester. You are now, for this purpose I want to give you some spoon feeding. I will let you know what is trial, what is the criminal trial, what are the stages and all these things. But the criminal investigation, enquiry, trial and all these aspects you are going to study in final year in the subject Criminal Procedure Code, and tentatively I will let you know what is this trial, what is investigation and all these things. So here what I want to tell you is Article 20 of the Indian Constitution contains three clauses. Clause 1 deals with ex post facto laws. Clause 2 deals with double jeopardy. Clause 3 deals with self-incrimination. So these three. So if an accused person can seek protection, can invoke protection under these three clauses: Article 20 clause 1, Article 20 clause 2, Article 20 clause 3. So this protection. So now we will have to know what is this ex post facto law, what is this double jeopardy, what is this self-incrimination. We have to know. I will give you its meaning in simple and then we will go in detail. So Article 20 clause 1 speaks about ex post facto law. Ex post facto law. So a person, if any accused person must be tried as per the law in force. As per the law in force. He should not be tried as per old law or as per future law which will come into force. So what is the law in force? Then according to that particular law only he should be punished. Suppose he is tried according to old law which is amended, or he is tried according to future law, that then he can that is he can challenge that punishment under Article 20 clause 1. For example, Dowry Prohibition Act came into force on 20th May 1961. So before, according to Dowry Prohibition Act, taking dowry is an offence. Accepting dowry is an offence. But in olden days, prior to that, their child marriages were there, taking and accepting dowry, giving and taking dowries system was there. So if a person has accepted dowry if, before 20th May, for that if case is filed after 20th May and that person is prosecuted according to old law, that person can accuse. So one Mr. X received dowry from Y before 20th May is correct, but that Y filed a case against, made a complaint to police or to the magistrate, and then criminal charges are leveled against him, and suppose the court gives judgment as per Dowry Prohibition Act and he is punished, then he can challenge the judgment or punishment of the court before High Court or Supreme Court. He can challenge. He can invoke protection. He can seek protection under Article 20, Clause 1 of this. That is what is called ex post facto law, irrelevant law, excessive law, or retrospective law. So this is what is called self-incrimination in brief. And secondly, that type of law is applied if any person is punished retrospectively. That law is prohibited by the government. Indian government prohibited such law under Article 20, Clause 1. American Constitution, American government under Article 1, Section 9 of American Constitution, the federal government of America also prohibited application of such law. Similarly, that Section 10 of Article 10, the states in America also prohibited such application of law. So in America and UK also, the person, if any accused person is punished applying ex post facto law, that is outdated law. So it was old law, but if it is amended, whatever law is there, suppose today we have Consumer Protection Act 1986. Consumer Protection Act has been amended in 2019. So here, the Consumer Protection Act 2019 has not yet come into force. So that is why, since it is not has that come into force, its gazette notification is not given, the 2019 Act should not be followed. The Consumer Protection Act 1986 also should be followed. If 2019 Act is followed, it is ex post facto law. Similarly, company law was originally Indian Companies Act. Indian companies were governed by Companies Act 1956, and the Company Old Act was repealed and a new act was passed in the year 2013. But even though the new Company Act was passed in the year February 2013, so many chapters did not come into force. For example, Chapter 20 of New Act 2013 Act, which deals with liquidation, which did not come into force for 3 years. Even though the New Companies Act came into force in 2013, but Chapter 20, that is liquidation, came into force after passing of the Insolvency Bankruptcy Code 2016. So when a new act is passed, when an amendment act is passed, so when a new act is passed, old act will be repealed or abolished, new act will come into force. Suppose the new act as a whole comes into force, sometimes new act comes into force, whole act will come into force immediately or after some time. Some chapters on different date, some other chapters on different date, it will be there. It should be specifically notified in gazette notification that what are the chapters that shall come into force and what date, all these things should be there. Similarly, Amendment Act also. Amendment Act is a temporary measure to delete some old provision and to incorporate new provision. Amendment Acts are there. So like that, our Indian Constitution, we have 114 amendments, and today there are 470 articles, 470 articles as on January 2020. Indian Constitution contains 470 articles divided into 25 chapters and 12 schedules. This is latest position. So there are 104 amendments in India. But whereas American Constitution, the American Constitution which came into force in 1789, our Indian Constitution came into force in 1950. But our Constitution came into force 1950 means ours is 70-year-old. But the American Constitution is more than 230 years old because it came into force in 1789. But American Constitution was within only 7 articles, 27 amendments. But Indian Constitution were 470 articles, 25 parts and 12 schedules, and we have 104 amendments. So like that, dear friend, so Article 20 of the Indian Constitution is one of the most important fundamental rights available to the accused persons. Accused person is one. He is a person who is arrested and before judgment, whether he is convicted, before his conviction or acquittal, after arrest, that person is called accused person. So until and unless judgment is pronounced by the court, if guilt is proved, he will be convicted, then he is called convict, and if guilt is not proved, he will be released. We say that he is acquitted. Before conviction or acquittal and between conviction or acquittal and arrest, the position of a person, man or woman, is called accused person. Article 20 of the Indian Constitution provides 3 categories of safeguards. 3 categories of safeguards to accused person. That is, Article 20 Clause 1 speaks about ex post facto law. That accused person in trial must be punished or acquitted according to to give judgment in respect of that accused person, which law is in force as on that particular day. That law alone must be followed. So no law which can apply old rule, or any law which can apply future rule cannot be applied. If any law apply following old rule, or if any law applying future rule which has not yet to come into force, and that person is punished unlawfully, unjustly, that accused person can approach the court challenging that his fundamental right is violated, infringed. Fundamental rights are that rights which are not only provided but also guaranteed. The High Courts and Supreme Court and through Indian Constitution, the Indian Constitution through High Courts and Supreme Court guarantees, ensures the fundamental rights to every individual. If fundamental right is challenged by, affected, infringed by any executive action or legislative action, that is law passed by central legislature or state legislature, any GO passed by the central government or state government, that aggrieved person can approach the court under Article 226 of Indian Constitution in High Court and Article 32 of Indian Constitution before Supreme Court. That is ex post facto law. Second one is double jeopardy. So Article 20 Clause 2. So an accused person should be punished only once only. Suppose he has committed theft of some 50,000 on sometime March in 2019. So he is already punished once. Once again he should not be tried and punished. So one offence, one punishment. One offence, 2 punishment are not allowed. If any person is punished once and again he is prosecuted and tried second time and punished second time, if it is done to any accused person, he can invoke defense under Article 20 Clause 2. He can approach the court. So double jeopardy means punishment for 2 times. For 2 punishments against one offence. This is double jeopardy. Suppose if any, this is Article 20 speaks about double jeopardy. Third point is Article Article 23, Article 20, Clause 3 speaks about self-incrimination. Self-incrimination. So here, nobody should be compelled to give evidence against him. So in a criminal trial or civil litigation, witnesses will be there from both the sides. With this topic, I will have to explain you. Then I will proceed to new topic. So in anybody should not be the evidence is more important. Evidence is more important, which forms the basis to give judgment. The judge will be able to give judgment basing on two sources. One is source of law, like legislation or custom or precedent or whatever, some sources. There are different sources of law. So according to 302, according to 300 IPC, it is murder. According to 302, it is life imprisonment or death sentence. That is, the judge applied legislation as a source. Suppose in certain communities in South India, one can marry his own sister's daughter, aunt's daughter, uncle's daughter. That is the custom provides. So he takes the custom as a source and gave judgment and declared the valid. So a judge, while giving judgment, he will take custom or precedent. Precedent means judgment given previously by some superior court, high court or supreme court, like that. So this is the judgment given in so and so supreme court or high court on so and so occasion. That precedents we are following, that can be taken as source. So like that, when judge wants to give judgment, he may take legislation or custom or precedent or some source he will take. So at the same time, even if the source is not available, but the judge is allowed to give judgment of his own, discretionary judgment, because the judges are provided inherent power without taking into consideration any source of law, custom, legislation, precedent or anything. If the judge who finds fit to give a particular judgment, he can give the judgment. That inherent powers are given to lower courts under CPC, CRPC provisions, Article Section 148 to 153, CRPC civil provisions are there. Under Article 226 and 227 High Court, that powers are there. Under Article 32 Supreme Court, such powers are there. But if evidence is not clear, the judge will not be able to give judgment. That is why evidence is most important. It forms the basis for any trial. It is in civil litigation or criminal litigation. If evidence is not there, suppose the evidence in a case, both parties will produce the evidence. They will produce witnesses to give evidence. Prosecution side, evidences or witnesses will give evidence saying that he committed the crime. So defense side, witnesses will come and give evidence the accused did not commit a crime, like that. Both sides are there. So apart from the evidence given by both sides witnesses, prosecution side witnesses give evidence that he committed the crime. Defense side witnesses say that he did not commit the crime. Opposite thing. So there will be examination of witnesses, chief examination, cross-examination, re-examination, everything there. Apart from everything, the evidence given by, the statement given by the accused is of great importance, but most important. That is why in investigation level police, enquiry and trial level court will put questions to the accused person whether he has committed the crime, because when he is asked to say truth, but he should not be compelled. No accused must be compelled to say that you give confessional statement. You say you say that I have committed the murder, like that. So by the no accused, not only people in general are not compelled to give evidence, but this Article 20 Clause 3 protects accused person, that in investigation level police, in enquiry and trial level court level, no accused should be compelled to give evidence against himself. If he is compelled to give evidence against himself or against will, it is violative of Article 20 Clause 3. he can invoke protection under Article 23. So these are the three most important topic, dear friends, which Article 20 speaks about. So Article 20 of Indian Constitution contains three clauses, namely Article 20 clause 1 deals with ex post facto law, Article 20 clause 2 deals with double jeopardy, double punishment, Article 20 clause 3 deals with self-incrimination, that no accused must be compelled to give evidence against himself. These are the three protections. So that is why among the articles enshrined under Part 3 of the Indian Constitution, Article 12 to 35, some articles give protection to people as a whole, citizens, non-citizens and corporations, that is legal person. Some articles give protection to citizens and non-citizens. Some articles give protection to some specific persons only. But in some articles also they give Article 15, Clause 1, Clause 2, Clause 3, 1 and 2 general, Clause 3 for women, like this. 15, 16, 1, 2, 3 in general. Clause 4 for education institution special provision is there, and in employment some special and there. So here in this particular case, Article 20 speaks about special protection to accused person. An accused is a person after arrest and before judgment. After arrest, before judgment, he is an accused person. Suppose A is killed, A is murdered. There is a doubt, there is a suspicion that B must have committed the crime. B must have committed the crime. So B must have committed the crime. On reasonable grounds, the police will go and arrest B and put him in police custody, present him before the magistrate. The magistrate may give direction to put him in remand for 10 days or 20 days, either in sub jail or central jail, whatsoever may be. During that period, time to time, he is called under trial prisoner. He is taken to court from some time to time. After investigation, inquiry and trial is over, he will be given, judgment will be pronounced by the court. If guilt is proved, he will be convicted. If guilt is not proved, he will be acquitted. From the time of arrest to judgment, as to conviction or acquittal, that person is called accused person. These are the three topics Article 20 speaks about. Now we have to discuss about Article 20 and other three concepts in detail. Article 20 is Article 120 is one of the most important articles of great importance, because after Maneka Gandhi case in 1978, three articles, namely Article 14, 19 and 21, they were described as golden triangle. Among all articles, Article 14, 19 and 21 are of utmost importance, and they were described as golden triangle. Next to that, one of the most important articles is Article 20 and Article 22. Article 20 provides three categories of rights, three categories of protection to accused persons. So, during emergency, fundamental rights are of such a great importance that gives the great importance. However, an aggrieved person should not approach the court to seeking protection fundamental right. Suppose during emergency proclaimed by Article 359 of Indian Constitution, suppose the President of India under 359 under Article 359 declares emergency. During emergency period, nobody should approach court even for fundamental right. So here, even in that time also, Article 20, 21 and 22, one can approach court even during during emergency. So nobody should approach court for protection of any right, including fundamental right, during emergency. But even though nobody should approach of High Court or Supreme Court for seeking protection of his fundamental right. But if his fundamental right under Article 20 or 21 or 22 is affected or infringed, for these things he can approach the court. So Article 20 speaks about these specific right. 21 right to life and personal liberty. Right to Article 22 speaks about prisoner's right. This aspect also we have to discuss in detail. So this is the thing. Now another thing is, one of the importance of Article 20 is such a great importance that if even though any accused personal constitutionally guaranteed protection under Article Clause 20, Clause 1 or Clause 2 or Clause 3 is infringed, he can approach the court even during emergency. Suppose any law is passed by central legislature, that is parliament or state legislature, and applying ex post facto law or double jeopardy or anything, it is absolutely unconstitutional. So that is why any law passed by central government or state government, they are strictly abolished under Indian Constitution under Article 20, Clause 1, Article Clause 1, Clause 2, Clause 3. Similar laws are strictly prohibited by Federal Government of American Constitution under Article 9, under Article 1, Section 9. And similarly, similar power is given to the states of America. There are more than 50 states in America. The state governments also are given power under Article 1, Section 10 to prohibit such laws. So India also, Indian Constitution also prohibits. So this is a constitutional protection given to the aggrieved. And now we have to discuss about Article 20 in general. Article 21, Article 20 in general. So already I told you Article 20 is of great importance. Even there are three categories of rights available to accused, namely ex post facto law, double jeopardy, and self-incrimination. If any action is taken violating these rules, that person can approach the court. So here, this is the position with reference to Article 20 of the Indian Constitution. So I already told you in under fundamental rights some fundamental rights are designed to citizens, non-citizens, including corporation, and some fundamental rights are designed to all citizens and non-citizens, that is foreigner. Some fundamental rights are designed only to specific category of people. So there is a bonded labor, some bonded, for example, bonded labor. Then secondly, this minorities and this accused person. Now we have to discuss about Article 20, Clause 1, ex post facto laws in detail. We have to discuss about Article 20, Clause 1, ex post facto laws in detail. So what do you mean by ex post facto law? So according to Article 20, Clause 1 envisages that no one should be prosecuted, convicted, which no one should be prosecuted or convicted under a law which is not in force. According to Article 20, Clause 1, no one should be prosecuted or convicted under a law which is not in force. Dear friend, in this connection, let us recall our attention towards Article 13, Clause 1, Article 13, Clause 2 define what is law. So our Indian Constitution came into force on 29th January 1950. 50 years and 20 years, our Indian Constitution is 70 years old. But American Constitution came into force in 1789. So nearly more than 230 years old. But here, our Indian constitution is the main law of the land, supreme law of the land. All laws in India passed by parliament or state legislature and subordinate bodies under delegated legislative power must be according to the constitutional provisions also. Suppose constitution one article says something, if any provision or any act says differently in central law or state law or subordinate law, that law is invalid, that law is void or unconstitutional. Suppose when parliament passes a law, that law, every care must be taken that no provision, no part of the act, no provision of the act is contrary or inconsistent with the provisions of the law. That is, according to Article 13, Clause 2, today if any law is to be passed, all the provisions must be strictly adhered to the provisions of the Indian Constitution. Similarly, our Indian Constitution, the supreme law of the land, came into force in 1950. However, during Second Law Commission time, so many laws were passed. That is, Indian Penal Code 1860 was there, Indian Contract Act 1872 was there, Indian Evidence Act 1872, they were there. Also, there are so many, more than 20 acts were passed in that period. They were passed long back to Indian Constitution. So, with even the old laws also, you are telling that if any laws should not be passed against to that. But if any provisions are there in old acts, if they are contrary to Indian Constitution, that particular provisions are to be declared void or invalid, and for that purpose so many arrangements are there, doctrine of flips and other things are there, that to that act that will be amended, and all these things I explained to you in Article 13, Clause 2, Clause 1 and Clause 2. So, given according to Article 13, Clause 1, any law which was contrary to Constitution, that area is void. Act may be act as a whole, a part of the act, or a section, clause, whatever it may be. So, all acts before Constitution must be according to Constitution. According to Article 13, Clause 1. All acts passed after Constitution must be according to Indian Constitution. So, that is why if any new law is passed, suppose a person is arrested and he is tried, he is in criminal trial, the court should apply law which is already in force. It should not apply old law, or it should not apply new law. Suppose old law is there, Amendment Act is there, what is the law exactly applicable as on today must be strictly followed. So, old law should not be followed, and future law which has not yet come into force should not be followed. As I told you, in Dowry Prohibition Act, it came in 1961. It came into force on 20th May 1961. According to Dowry Prohibition Act, taking dowry is offence. Before 20th May, receiving dowry was not offence. Suppose a man who received dowry before 20th May is prosecuted after 20th May, it is application of Expost facto law. That man can challenge the decision of the court under Article 20, Clause 1. So similarly, consumption of alcoholic drinks. Today the consumption of alcoholic drinks is not offence today. Tomorrow one new government will come. The new government, before coming to power, made a promise. If we come to power, we abolish consumption of alcoholic drinks. The type of promise was made by Chief Minister N.T. Ramarao in 1986. The first signature after his swearing-in ceremony was abolition of consumption of alcoholic drinks. So yesterday consumption of alcohol drinks was not offence. Today it is offence. But we cannot punish anybody today for having consumed alcoholic drink 1 week back or 10 days back. So this is what is called this thing. So these are the various issues relating to this ex post facto law. Now, the Article 21, Clause 1 runs as follows. No person shall be convicted of any offence except for violation of a law in force at the time of commission of the act charged as offence nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. So if nobody should be convicted offence, so he must be convicted according to law at present only. Future suppose old act, less punishment, less fine, but according to new act or amendment act, more fine, more punishment, so that should not be applied. For example, originally the punishment for rape, Indian Constitution section 375 IPC defines rape, and 376 prescribed punishment for rape. Earlier punishment for rape was 10 years, subsequently life imprisonment was made, subsequently death sentence was incorporated, and to that effect recently Union government after Nirbhaya case, Criminal Law Amendment Act 2013 was passed in Andhra Pradesh to speed up the procedure. Andhra Pradesh Criminal Law Amendment Act 2019, popularly known as Nirbhaya Act, was passed. In Nirbhaya case, one minor was not given death sentence along with four others. There was an uproar, and that boy also was to be given death sentence. To that effect, the Protection of Children Against Sexual Offences Act was Sexual Offence Act 2012 was amended in 2019, which is yet to come into force. It prescribes punishment even to the minor between 16 and 18 years. If he is found guilty and brutal, death sentence also can be prescribed for that person also. These are so many things are there. Suppose if any, according to this, suppose as per the law it should be followed. Suppose it should not be, if the amended act prescribes more punishment, more, it should not be done. Suppose in those days rape is committed, maximum punishment was 16. Subsequently amendment act came, life imprisonment, but life imprisonment should not be given. If life imprisonment is given, he can approach the court and invoke protection under Article 21. This is the position. So these are the various issues. Now we have, dear students, your conviction. In these some convictions are, some words are used. What do you mean by conviction? If arrested person, if judgment is given, guilty is proved, if he is given punishment, imprisonment is pronounced, then we say that person is convicted. For he is convicted, so that process is called conviction. If guilt is proved, no, he did not commit murder, guilt is not proved, then we say that he is acquitted. That is what law in force. What is the law in force today should be applied. Whether the law must be passed, there must be gazette notification must be given by the Ministry of Home Affairs. The act as a whole with effect from what date? Does any law it should be finalized by the Law Commission. It is to be presented in Lok Sabha, Rajya Sabha. It should be assented by the President of India. It will come back to the Home Department, Ministry of Home Affairs, and it will be notified in a gazette notification. And what date the law has, the act as a whole should come into force should be specifically mentioned. The act as a whole should come into force. Part of the act will come into force. Some acts are passed and some parts are come into force, but even after presidential assent, some acts have not yet been come into force. For example, Consumer Protection Act 2019 was assented by the President of India in August 2019, but it has not yet been come into force because gazette notification is not given. That is why the consumer forums are following old law only. So these are the various things. So that is why now what is let us go to meaning. What is the exact meaning of ex post facto law? Ex post facto law means excessive law or irrelevant law or retrospective law. It meaning ex post facto law means after the fact. Ex post facto means after the fact. So act was done long back, action is taken today. That is why that is called after the fact. It is retrospective law. Retrospective law, for example, the government wanted to give DS to employees. So the DS are due from last year 2019 January 1st. Today government decided to give DS. So retrospective date means from which date they are due? 2019 January 1. If it is given, it is retrospective. No, we have no money, we don't give from retrospective date, we will give from back date only, present date only. That is from 1st July. This is prospective. The DS are given from 1st July 2020, it is prospective. If they are given with arrears from back date, that is called retrospective. So, this ex post facto law is called retrospective law, excessive law, or backdated law. So the word ex post facto law is derived from out of the afterbeat. Ex post facto. The ex post fact derived from ex post facto. It is a Latin word. It means out of the aftermath. That is a law that gives retrospective consequences unjustly for an act committed. This is the meaning. So this ex post facto law is based on American Constitution, Article 1, Section 9 of the American Constitution. Similarly, in American Constitution, Article 1, Section 9 prohibits ex post facto laws. Similarly, Article 1, Section 10, the states in United States of America prohibit ex post facto law. The American federal government prohibited that particular law. In Indian government, and Article 20, Clause 1 prohibits such ex post facto laws. Ex post facto law. So these are the various issues relating to ex post facto law, dear student. Now we have to discuss about this ex post facto law can be explained under three categories. There are three classes. First one is subsequent law declares an act punishable. Second is subsequent law enhances punishment. Subsequent law changes the procedure. Suppose for punishment of a particular crime, there is already law is there. Suppose some new act is passed. According to old act, punishment is less. According to new act, punishment is more. According to new act, fine also is more. In such a case, ignoring the old act, new act, the punishment, for this punishment, the accused deserves punishment according to old law, lesser punishment, lesser fine. But according to new law, more punishment, more act. Just like rape, earlier 10 years, now say life imprisonment or death sentence. So similarly, fine. Earlier less fine, today more fine. So if subsequent act prescribes more punishment and more fine, if it is applied, the aggrieved can approach court and invoke protection under Article 20, Clause 1. Article 20, Clause 1. That is first thing. So there is a relevant case also is there on this point. Second one is subsequent law enhances. First, this is the second point. First point, earlier the subsequent law, according to old law, there is no punishment. According to new law, punishment is there. For example, consumption of alcoholic drinks. There is accepting dowry. Before 20th May, after 20th May, it is offense. So, first category is if new law, that is subsequent law, prescribes punishment for a particular act, that is consumption of alcoholic drinks today or taking dowry today. Previously, there was no punishment for dowry accepting, but today it is punishable. So, if subsequent law punishment is prescribed, previously no punishment, that law can be challenged under Article 20, Clause 1. Second one is, if subsequent law, that is new law, increases the punishment and increases fine, this also can be transferred. Suppose the new law prescribes the procedure, it cannot be challenged. So, the accused can invoke protection under Article 20, Clause 1 to release. If new law creates the punishment, it can be challenged. If new law increases punishment and increases fine, it can be challenged. If new law changes the procedure, it cannot be. So therefore, criminal investigation, inquiry, trial, there is lot of procedure. After Disha murder case, gang rape case, the Disha gang rape case in Hyderabad activated Telangana government and Andhra Pradesh government. They have taken stringent steps. The Andhra Pradesh government passed Andhra Pradesh Criminal Amendment Act 2019, popularly known as Disha Act. That act prescribed a quick trial, investigation only in 17 days, and inquiry and trial in only court level 14 days. Within 21 days, the judgment should be given and the culprit should be punished, and appeal procedure and other provisions will be there, mercy and other. This is the act. Suppose that act is passed prescribing new procedure that cannot be challenged. So for first, if punishment is newly created, it can be challenged. If the new law increases the punishment, enhances the fine, it can be challenged. However, if new law enhances tax liability, that cannot be challenged, because this is a protection to government. There are relevant cases also on this point. Dear friend, this is old. Now, so here in Article 20, Clause 1, case law is here. Kedarnath versus State of West Bengal. In this case, what happened was, the accused Kedarnath in this case purchased gold from foreign country, and he did not give any declaration. For that purpose, he was punished. He was prosecuted and punished under Customs Act 1947 Act. Subsequently, he was also charged under Foreign Exchange Regulation Act. In first act, he was not punished. In second act, under Foreign Regulation Act, he was tried and punished. He wanted to. He said that since he was not tried and punished in first act, he can be tried and punished in the second act. This is applied for double jeopardy also. And this is one thing. Shivdutt Rai versus Fateh Chand Union of India. So there is no protection. Article 20, Clause 1 in for tax enhancement. Suppose the government collects heavy tax, it cannot be challenged. This was said in Shivdutt Rai Fateh Chand versus Union of India. This is about some cases you can go through. And second topic for discussion is double jeopardy. Double jeopardy means double punishment. When the accused committed an offence, if a person committed an offence once, if he is already punished, he should not be tried and charged and tried and prosecuted again or punished again. This is what is called double jeopardy. Suppose A committed some murder, rape or anything, some 10 years or 7 years imprisonment is given. After punishment is over, again he is charged with offence and convicted. He should not be. That time severe punishment was not given. Again, charge sheet should be framed. He should be prosecuted again, punished again. It is done. He can invoke protection under Article 20, Clause 2. Article 20, Clause 2 speaks about double jeopardy. It means double punishment for the same offence. A convict is tried and convicted again for the same offence. So one offence punishment or two punishments are punishment for two types. So Article 20, Clause 2 prohibits double jeopardy, and the accused or convict can seek protection, invoke protection under Article 20, Clause 2 of the Indian Constitution. So the term double jeopardy refers to the danger of conviction that an accused is subjected to trial again even after having been tried and convicted. So the term double jeopardy refers to danger of conviction. It's a danger of conviction. Once convicted again attempt is made to convict, it is a danger of conviction. So this should not be done. So that is why the term double jeopardy refers to danger of conviction that an accused is subjected to trial again even after having been tried and convicted. Article 22 class 2, Article 20 class 2 declares that no person shall be prosecuted and punished for the same offence more than once. So this doctrine of double jeopardy is based on Latin maxim, common law maxim, that is England, that is the common law maxim, nemo det bis vexeris. This means a man must not be put twice in peril for the same offence. So this doctrine, double jeopardy, is based on English common law, that is English common law maxim, namely nemo det bis vexeris. This means a man should not be put to peril twice for one offence. So peril means is a device that claims the demise of the subject matter. So punishment to accused is peril. So accident kills a human being. Accident is peril. So there are so many perils, marine perils. Ships are insured against, ships are called vessels. They are insured against so many perils: stranding, shipwreck, foundering at sea, collision, and all. Inherent vice, all these things. So similarly, the human life is taken away by so many perils: accidental death, earthquake, accidental tsunami, flood, disease. All are various kinds of peril. Peril is a device that takes the life of human being, that takes the life of subject matter. Human being is subject matter in life insurance, property is subject matter in non-life insurance, vessel, ships, ship freight, they are subject matters in marine insurance. So these are the, so here Article 20, in Article 20 there are two aspects. What are the two aspects? Atre fois convict, atre fois acquit. Atre fois convict means a person has already been convicted previously for the same offence. Atre fois acquit means a person has already been, atre fois acquit means a person accused is charged on same offence for which he was already prosecuted and convicted. So this is the position. So the state practice. So the double jeopardy is strictly prohibited in UK and US. Here in UK and US, once the accused is tried, whether convicted or not, immaterial, whether convicted or acquitted, again he is charged and prosecuted. The second time prosecution is invalid. It is violative of it is a violative of constitution. It is unconstitutional. But in India, first time tried and convicted, second time again tried and convicted, this defense is available. If first time tried and acquitted, the second time tried and convicted, the defense is not available. So in America and UK, once tried for same offence is enough. Whether convicted or acquitted is immaterial. So when once second time tried, convicted second time, he must not be tried second time. But in India, first time tried but acquitted, second time tried, convicted, it is valid. So that is why to invoke protection, it was laid down in Thomas Das versus State of Punjab that one who wants to, if the if the accused wants to invoke protection under Article 20 clause 2, he must prove three conditions. Firstly, he must be an accused. Secondly, he was tried by tribunal or court. Thirdly, he was convicted. Three conditions must be satisfied. So case law. Maqbul Hussain versus State of Punjab, State of Bombay. In this particular case, the appellant, in this case, the appellant purchased gold, and he did not give any declaration to that effect and defect, but the gold was seized, and subsequently in Foreign Regulation Act the case was charged. In earlier conviction was not given, but subsequently conviction is given, it was held valid. So these are the two concepts I have covered. Third one is self-incrimination. Self-incrimination means giving evidence against himself. So, no, Article 20, Clause 3 of Indian Constitution ensures accused. Not only every individual, no one must be compelled, forced to give evidence against himself. Like that, according to Article 20, Clause 3, self-incrimination. Suppose he accused when a person is arrested, there are 3 stages. The investigation, enquiry and trial. Investigation is at police station level, enquiry and trial are at court level. So trial is to put to make all investigation, all enquiry except guilt or fraud. In trial, only everything is inquired with reference to guilt or not guilt. So, in investigation level, police will put so many questions to accused. In enquiry level, trial also, the accused will be put to so many questions. When questions are asked, he should give answers suo moto. So, the case is the main source of evidence to give trial, to finalize the trial, to give judgment is accused statement. Generally, no accused will give correct information, because even though he has committed particular crime, he will say that I have not committed any particular crime, he will say. So, if at all, he should be, that is why, in order to find out the correct information from the accused, so many methods are adapted. So many methods are adapted. So simply brain mapping test, highly sophisticated science and technology, lie detectors are there, narco analysis tests are there, all these things are there. So in every criminal case, there will be witnesses from prosecution side, witnesses from defense side. With defense side, witnesses say that the accused has not committed the crime. Prosecution side witnesses give evidence that he has committed the crime, which will have more strength. Basing on that, it will. So, out of evidence given by prosecution side and defense side, the statement given by accused is of more importance, because the accused is the right person who knows that whether he committed that particular crime or not. In order to trace out correct, genuine information, genuine statement and truth, so many methods were adapted by the police people and court people. But however, so here in this correction, I want to tell you self-serving statement, self-harming statement. Self-serving statement means if the accused says that I have not committed that crime, it is self-serving statement. If the accused says that I committed that particular crime, it is a confessional self-harming statement. Self-harming statements are called confessions. The self-harming statements are called confessions in criminal law. In criminal case, the self-harming statements are called admissions in civil law, civil litigation. So that is why if any confessional statement is made to police officer, it is not allowed, it is not admitted under section 25 Evidence Act. If any under 26, if the magistrate instigates the accused, you agree that you admit that the offence is committed by you, I will reduce your punishment. So if the accused is compelled to give evidence by the judicial officer in court, that is also not admissible. So confessional statements given to police officer are not admissible. Confessional statements given in court are admissible. They are only admissible. They are admissible. So that is why, according to Article 20, Clause 3 of Indian Constitution, the accused, either at investigation level or at enquiry level or at trial level, should not be compelled to give any evidence, any witness. So the self-incrimination statement means Article 20, Clause 3 declares that no person accused of any offence shall be compelled to be a witness against himself. So, as an accused can never be a witness in his own case. So, there will be witnesses from prosecution side, witnesses from negative defense side, but he cannot be a witness against himself for commission of the offence. No accused shall be compelled to give evidence against himself. If confessional statement is forced to give confessional statement, it is violation. But however, Article 27, Section 27 of Indian Evidence Act provides an exception. Suppose the accused gives a confessional statement on his own without any compulsion. He gives only, I have committed murder of so and so. I hid him in my garden, and I will show you. Where the body is buried. Then the first part of the confession statement is not admissible, but second part of the Pulukuri Kotaya case is there, and one Mr. Sivaya killed Kotaya, and he gave confessional statement in police station. I have killed him and buried him in my garden. If you take me to that point, I will show you. If that particular here, the question is whether section 27 of Indian Evidence Act is constitutional or unconstitutional. So, if any statement given against any confessional statement, any evidence given against himself by accused in court or police station or anywhere, suo moto and followed by subsequent follow-up action, it is not unconstitutional. If it is given by compulsion without his conviction, that is unconstitutional. In narco analysis tests, that is why in order to find out the correct information from the accused, the authorities resort to so many tests. So that is why there is a so the evidence given by accused will be of great importance. So there are so many tests are there. In police will try their level best to trace out the make him speak truth, and in trial level, interrogation level also, so many attempts were made to extract the truth for the purpose, in order to get truth whether he committed the crime or not. They administer lie detectors, highly sophisticated science and technology oriented lie detectors are there. In order to ascertain truth from accused person, a polygraph test is there, brain mapping test is there, and finally narco analysis test is there. Narco analysis test is of great importance, but when narco analysis test, it is some drug is administered in a 300 ml distilled water, some chemical is added in it, and some that injection is given, and he will give correct truth. When narco analysis test is to be administered on the accused to find out correct information, the court must give permission